heard by video?
That would be fine. I don't
Okay,
have a problem.
Judge, real quick, Katrina, can you let Julia in, please? I'm sorry, excuse me, Judge.
Yeah, hold on.
you're fine.
Hold on. I'm switching back and forth screens here. Hold on. I had to do the live thing. I'm giving that in.
And Ms. Jinks, is this your case? Okay, just wanted to make sure.
Yes, it is.
Are
Ms.
you okay,
Burwell?
ma'am? I'm sorry. I just noticed
I'm sorry, what was that?
I think she was asking as to your health. Ms. Burwell, can you hear me okay, ma'am? Ms. Burwell, can you unmute for me? South Annex, please. Ms. Burwell, you have been charged in case 22 CR 008488J with criminal trespass. Let's see. Good afternoon, Ms. Harrison.
Good afternoon, Judge. How are you?
I'm doing well, thank you. I hope you are as well. Is there a
Thank
history?
you.
Good.
4 cycles with history in Georgia and Virginia. Last arrest was July of 2019 for failure to appear in Fulton County. Underlying charge was not indicated. I show 1 conviction in 2008 out of Virginia, which was driving under the influence, misdemeanor conviction. She is recommended for UJR through the jail, Judge. Nothing further.
Okay. Mr. Vogel?
Thank you, Honor. The state right here is asking for a $1,000 surety bond and to stay away from 1916 Piedmont Road, along with no guns, drugs, and alcohol while on bond. Ms. Burwell, she was sleeping at that 1916 location after being asked to leave by management a few times. Again, $1,000, that's about as low as we go here on the sureties. Due to Ms. Burwell, multi-state offender and the FTA, it's a little bit concerning. But no other conditions besides that stay away and no guns, drugs, or alcohol. Nothing further.
Okay, it's gonna be $1,000 signature bond through the jail.
Excuse me.
Hold on.
No, don't speak, Ms. Burwell.
I'm
Okay.
gonna give you a signature bond, Ms. Burwell. But you have to stay away from 1916 Piedmont Road and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Jenks?
Yes, thank you, Judge.
Okay, very good. Good luck to you, Ms. Burwell.
Thank you, sir. Have a wonderful one.
You do the same, ma'am.
Judge, the reset date for the SAP counter, I forgot to make that announcement. It's
Okay,
January the 10th, 2023.
January 10th. Thank you.
Mhm.
Who do we have next?
Petition number 3, Ms. Cherry.
Good afternoon, Ms. Cherry. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Cherry, you've been charged in case 22 CR 008489Y with criminal trespass. Is there a history, Ms. Harrison?
Your Honor, 1 cycle. That arrest was June of this year for criminal mischief, damage or delay railroad disorderly conduct, and that was by Amtrak, Pennsylvania. No disposition listed in that arrest.
Mr. Berger?
Thank you, Honor. We're asking for a $3,000 surety bond with the conditions of no further contact with Malaysia Campbell. That's spelled MYLASIA Campbell. Stay away from 2255 Lenox Road. Enrollment in our 1-day anger awareness program, and no guns, drugs, and alcohol while on bond. Your Honor, it looks like Ms. Cherry was a friend of Ms. Campbell's and was staying at Ms. Campbell's home because her flight had gotten delayed. Ms. Campbell and Ms. Cherry got into a fight, it appears, and Ms. Cherry was seen kicking at Ms. Campbell's window and rummaging through her belongings when Ms. Campbell was gone. That was when Ms. Campbell decided that she had had enough and asked Ms. Cherry to leave. And that's when Ms. Cherry threw a candle through Ms. Campbell's window, shattering the window. So we see the 1 cycle from out of state of Virginia it sounds like it was a similar type charge of anger and damaging property. The fact that Ms. Campbell doesn't appear to be a Georgia resident, that's also a little concerning for the state. And to break a window with this cold, we do think that a $3,000 surety bond would be appropriate today. Thank you.
Ms. Jenks?
Yes, thank you, Judge. Well, first and foremost, we don't have any of the facts related to that one cycle that happened with Amtrak, Judge. And actually, Ms. Cherry is a resident of Atlanta. She's a 37-year-old woman. She has a Bachelor of Arts from the Art Institute of Atlanta. She graduated in 2007. So she's actually been in Georgia since 2003. She's got significant family ties, Judge. She has her cousin, his wife, and kids who live in Alpharetta, and her godmother is also here in Southwest Atlanta. While the facts of the, of this actual charge are not in dispute, are, not involved right now, she did say that the alleged victim in this did try to sexually assault her, which is why she was acting in self-defense. There were also two other men there, Miss Campbell's brother and another man, and the four of them had been starting with her, and she was actually trying to get away from them. When the police came, they started throwing her stuff out of the house, and when the police came, she tried to explain that, and then she was arrested. We're asking you to give her a signature bond through pretrial. We have no problem with the state's condition of a one-day anger management class as a condition of her bond, Judge, but she does have a place to live. She will be living at 830 Pryor Street, Northwest, and she is working. She has 3 different jobs that she does. She does freelance design through her own company. She also works for So Far Sounds, which is an entertainment company, and then Chez Montier, which is a catering company. The second 2 she's been doing for about a year, and she's had her business for longer than that. So again, Judge, we're asking you to allow her to sign herself out of jail.
And Your Honor, real briefly, Ms. Campbell is here on the Zoom. If we could give her the opportunity if she would like to speak.
Okay, thank you, Mr. Berger. Ms. Jenks, is there any reason that Ms. Cherry needs to go back to the Lennox Road address to retrieve any belongings?
No, that's
Okay.
my understanding is no, that's not necessary.
All
And she
right.
has no problem staying away from Ms. Campbell and the location of the incident.
All right. Ms. Campbell, good afternoon. I'm Judge Eric Morrow. This is your opportunity to address the court if you would like to do so. Of course, you do not have to do so, but if you would like to speak, I'll need for you to raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you, ma'am. You can put your hand down. What would you like to tell the court?
Okay. So I would like to tell the court that I would just like to tell the court that I would like to maintain no contact with her. I will say that there are some missing parts to what she is saying, because I would not agree that she was acting in self-defense, because she was asked to leave several times. And even when her things were placed, nobody threw her things outside of the apartment. They were placed outside of the door, and she was asked to leave. She refused to leave several times. Excuse me, this was spontaneous. I wasn't expecting to be in court just now, so I just wanted to show my face. Apologies. But she destroyed property and broke into my house, claiming to try to get things after she was already given all of her things, down to the snacks that were purchased. So that's so how this is being said right now is untrue. And then 830 Pryor Street is not her home. That's an Airbnb that she was staying in, because I was friends with her, and I also visited that address that she gave as a place that she's staying. If that is the case, how come she was not there? How come she came to my house? 830 Pryor Street is actually way closer to the airport than Lennox Woods Apartments. So if this is the place that she has to stay, then why was I asked to open up my home?
Judge,
Okay.
You understand?
we're
So that's
gonna,
why
we're gonna ask you
Okay.
to disregard all
I
of
just do
the
not
relevant,
want, I don't want.
irrelevant testimony related to where Ms. Cherry is living. Again, there's no problem with a no further contact order from Ms. Campbell, and there's absolutely no problem having a stay away order put in place as a condition of her bond. Again, we're asking Your Honor to allow her a UJR.
May I say
Miss-
something, please?
Miss Cherry, let me just explain to you. Today is not the day that we're litigating this matter. You'll have maybe your day in court to tell your story at a later time. Today is only for a bond hearing. And as for that bond hearing today, I'm going to order that she not come back to your home and that she have no further contact with you, okay? So you'll be able to, if necessary in the future, you'll be able to give whatever part of your story you'd like to give, okay? Ma'am?
Are you talking to me or Miss Cherry?
Oh, I'm sorry. I'm talking to you, Ms. Campbell.
Okay, so I understand that. I just also wanted to say that I never wanted her to be arrested. I had a police officer show up to the premises and just asked to take her to wherever she requested to go or to a safe place, being a warming shelter of some kind. He told me that he was going to take her off of the premises. She also promised that she was going to leave the premises. And once she made that promise and the officer left, after that is when she returned to my home and kicked out my window and went into my house. So that's why, for me, as the person who has to deal with all of this, I don't want her to have a signature bond, because she could sign out and Uber right back to my house and do the same thing.
Well, if she does that, Ms. Campbell, she's going to be in violation of my bond order, okay? And if that's the case, if she's in violation of my bond order, she will be picked up and arrested again. You understand me?
I understand.
Okay, very good. And I hope you understand me also, Ms. Cherry. I'm going to allow you a $2,000 signature bond through pretrial, one day anger awareness class, no further contact with Ms. Campbell, stay away from her residence at the Lenox Road address, and no drugs, alcohol, or weapons while out on bond. Let me be clear with you, Ms. Cherry, what no contact means. It certainly means no physical contact, no phone contact, no internet contact, no social media contact, no contact whatsoever, okay? So if there is contact, you're going to be in violation of this bond order and you won't get a signature bond the next time, okay?
Okay, I understand, sir. Thank you.
All right, very good.
Thank you,
Good luck
Judge.
to you, Ms. Cherry. Good luck to you also, Ms. Campbell.
Thank
Y'all
you
have a
all.
good
Happy
afternoon.
holidays.
Guys, I hate
Awesome.
you repeat that over again. What was the bottom?
It's $2,000 signature bond through pretrial.
And you said a one-day angry awareness class?
That's correct, yes. And the
Okay.
stay away and no drugs, alcohol, or weapons.
Have a seat.
All right, thank you. Thank you all. Happy
I will-
holidays.
Okay, have a good afternoon.
Thank you.
Are we going?
Now, Position 12, Ms. Wright.
Hold on, Ms. Milton. I have some visitors here.
Okay. Have a seat, please.
No, Francois, I'm sorry. Let Ms. Milton go, because it looks like she has a ruling inmate in the courtroom, so let her go. Thank
Okay.
you.
Sit down, please.
Judge,
Okay,
Judge, if I may please request a breakout session to discuss Ms. Wright just briefly.
okay. So tell me, first of all, let me know, is this Ms. Wright that we have at the South Annex?
Yes,
Okay.
sir.
And Ms. Holly, you would like a breakout with myself and the solicitor, is that right?
That's correct.
Okay. And Ms. Backus, good afternoon. Is this your case?
Yes, Your Honor. Good afternoon. Merry Christmas.
Merry Christmas to you also. Ms. Lewis, so can you place Ms. Holly, Ms. Backus, and myself into a breakout room?
ASG Courtney Salette as well.
And
She's
and I'd
supervising.
like to be invited too.
Okay, well, everybody come on to the breakout room.
Already in the breakout room.
Okay. Good afternoon, Ms. Wright. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Wright, you've been charged in case 22 CR 008496F with simple battery family violence. I've had the opportunity to have a conversation regarding your case with the solicitor and with your lawyer, and it's going to be a $3,500 good bond. At this time, no further contact with Melvin Brighton and mental health.
Britain, and
Okay.
my father and my children's lives are in danger.
Okay, hold on.
Ms. Wright, remember when I said that we're not gonna have any conversations with the judge right now?
Okay, go ahead.
Okay, so a mental health evaluation and treatment if necessary. Stay away from 135 address, and no drugs, alcohol, or weapons while out on bond. We've also discussed if it becomes necessary that you have to, or that if you wish to get out to attend any proceedings in the near future, that I will allow you to do that, okay?
Okay.
Ms. Lewis, when is the next competency calendar?
One second. Let's see. Next calendar will be. We setting it for 2 weeks from now. Will be Thursday. It will be the 12th of January.
Okay, we'll put her on that January 12th calendar. Ms. Holly is going to get you, Ms. Lewis, a mental health evaluation. Also, Ms. Holly will notate that if Ms. Wright does need to get out, that she will come back to me to sign any orders in that regard. Ms. Backus or Ms. Holly, anything further?
Nothing further, Your Honor.
No, Your Honor, thank you.
All
I'm
right,
sorry,
good
Judge,
luck.
what was the bond?
It's a $3,500 good bond.
Thank you.
Okay. All right, Ms. Wright, good luck to you, ma'am.
Thank you. Have a blessed day.
You do the same, ma'am. Who do we have next?
Position 7, Miller.
Good afternoon, Mr. Miller. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're doing by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Miller, you've been charged in case 22 CR 008493H with driving under the influence of alcohol, less safe, and driving on the wrong side of the road. Is there a history, Ms. Harrison?
Judge, no prior history.
Okay, Mr. Boger.
Thank you, Honor. The state's asking for a total of an $8,000 surety. That's $4,000 for the DUI less safe, and then $4,000 for driving on the wrong side of road. With the conditions of no driving without express consent from the DDS, enrollment in a defensive driving class, alcohol drug screening, and a MAD victim impact panel. Your Honor, we're lucky that we're here, that this case is a misdemeanor. Mr. Miller had hit another vehicle head on the corner of Highway 92 and Highway 9. When the officer arrived, Mr. Miller was speaking with the victim in this case, taking responsibility for what had happened. He also admitted to the officer that he was drinking and driving, but did decline to give a breath sample or engage in any field sobriety tests. This case, it looked like a concerned citizen tried to stop Mr. Miller before this accident occurred because a bolo was put out for Mr. Miller's car because he was seen throwing an alcohol bottle out of his window. Just again, this is a pretty serious DUI to hit someone head on, especially over in Highway 92. Nothing further from the state.
Jinx.
Thank you, Judge. Mr. Miller is 43 years old, Your Honor. It is his first arrest. He has lived in Georgia since 2015. He has his GED. He's been working in in recycling as a supervisor. He's working for SNA Recycling in Doraville from 2016 to 2019. And then currently, and for the past 3.5 years, Judge, he's been at the Olympus Recycling Plant. And again, there he is a supervisor. He lives with his girlfriend. We do have an address for him in Roswell. He's got significant ties to the community between his work and his girlfriend and living his life here. We are asking you to consider a signature bond in this case. We would be fine with an alcohol and drug evaluation as a condition. I didn't catch all of the other conditions, but it seemed like the state basically said all of the conditions if someone was convicted of a DUI. So I may have misheard that. So maybe Mr. Borger can make that request again, but we would be amenable to having him do an alcohol and drug evaluation and obviously abide by any kind of limitations that DDS put on him, which is a whole separate track for this. But again, we're asking you for a signature bond, Judge.
Anything further, Mr. Berger?
Yeah, the state was asking for the enrollment in the risk reduction and a victim impact panel, just in part because the defendant himself admitted to drinking and driving. So hopefully we can get some of the sentence recommendation underway as he awaits to get his license back and awaits sentencing.
And Judge, again, that is actually the sentence for a first DUI. Those are minimum mandatory requirements. He is innocent right now until proven guilty beyond the exclusion of every reasonable doubt. We really don't know the facts of the case. I know in another DUI that we have here on your calendar, Judge, the officers decided not to administer the field sobriety exercise because it was below freezing out. So I don't really know if this was something that wasn't consented to, or if it was just a matter of the weather conditions. Again, all of that is for down the road. But we're asking for a signature bond with the ADT and obviously the DDS requirements.
So for the DUI, it's going to be a good bond of $1,750. For the driving on the wrong side of the road, it's going to be a good bond of $250, which makes for a total of a $2,000 good. Abide by any DDS limitations, alcohol, drug evaluation, and treatment if necessary, and no drugs, alcohol, or weapons while out on bond. Okay.
Your Honor, can you repeat the bond total for the driving on wrong side?
250.
Okay, thank you. I see.
So it totals 2,000. I hope.
Got it. Thank you.
Okay. All right. Good luck to you, Mr. Miller.
Thank you, Judge.
Thank you, Judge.
Welcome.
Position 5, Ferguson.
Good afternoon, Mr. Ferguson. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Ferguson, you've been charged in case 22 CR 008491E with battery family violence. Is there a history, Ms. Harrison?
Judge, 4 cycles, last arrest June of this year for a probation violation. Underlying charge was not indicated. Record indicates an open case pending for theft by shoplifting. Case number was not indicated. It appears to be an open case. Nothing further, Judge.
Thank you. Mr. Rover?
Thank you, Your Honor. The state's asking for a $3,000 surety bond with the conditions of no further contact with Miss Niley Cruz. That's spelled Nayellie Cruz, Cruz. Stay away from 295 East Belle Isle Road. Enrollment in a family violence intervention class, or at least the 1-day anger awareness class, and no guns, drugs, and alcohol while on bond. The Honor, in this case, the defendant threw an object at Miss Cruz's nose, which caused some bleeding. Miss Cruz lives with Mr. Ferguson. Right now, it's charged as a battery family violence, but of course, when there's objects being thrown and you have some cuts to the skin, this could escalate to a felony. I see that Mr. Ferguson was also arrested in 2013 for simple battery and also has an outstanding case currently. So I think the $3,000 surety is the least that we can do for a defendant with an outstanding case and with the history of violent arrests. Nothing further from the state.
The simple battery in 2013, do you know what the result of that was?
I don't have a disposition.
And do you know what he was on probation for?
I don't.
He told me
Judge.
that he was on probation for a traffic infraction in Sandy Springs, Judge,
Okay.
and that was closed out.
And did you have something to say, Ms. Harris?
I'm sorry. He had a 2015 misdemeanor conviction in Cobb County. I did not show any conviction for battery in the GCIC.
Okay. Thank you. Ms. Jenks?
Yes, thank you, Judge. Mr. Ferguson is 26 years old, Your Honor. He's born and raised in Georgia. He graduated from Riverwood High School here in Sandy Springs. He didn't go to college, but he's been in landscaping ever since high school. And right now, up until he was arrested, he was working at the Arlington Memorial Park, basically as a groundskeeper and undertaker there, helping to bury the coffins. And then he also has another job at Imagine Exhibitions, and he's been working for Arlington since December of 2021. And he's been working at Imagine Exhibitions since October of this year as a audiovisual tech support. We're asking you to consider a signature bond in this case, Judge. I don't believe he has any violent history. I think pretrial confirmed that. Like I said, the probation violation the probation violation from June 2nd of this year, my understanding was a traffic infraction in Sandy Springs. He was under the impression he just had to pay the fine, and he had more time than what I guess they told him. He did in fact pay the fine, and that was closed out. So we have no problem with, I don't know if they asked for no further contact or no further violent contact, but that's not an issue, and a one-day anger management class as a condition of bond. But we would ask Your Honor to consider a signature bond in this case.
Will he need to go back to the Belle Isle Road address to pick up any belongings?
No, he has.
Judge, I'm sorry. Excuse me, I'm sorry. Ms. Cruz is in the galley in courtroom number 3. The alleged
sorry?
victim.
Oh, okay. So does she wish to speak?
Hold on one moment. Yes, Judge, can you give me one moment, please? Thank you.
Okay.
You can come right here, ma'am.
Good afternoon, Ms. Cruz. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, ma'am. It's my understanding that you'd like to speak in regards to Mr. Ferguson's matter. Is that correct?
Yes, sir.
And what would you like to tell the court?
I believe his name is Mr. Borger. Everything that he stated is completely false. He never threw anything at me when the cops arrived. I told him he did not put his hands on me. They kept asking me, and I told him he did not do anything. He did not put his hands on me. They asked me about a scratch I had, which my dog caused, and they told me it's not up to me. They're going to go ahead and take him, sorry. But everything Mr. Borger said, he did not throw an object. Everything he said is completely false. I'm not pressing charges. I am not a victim because he never put his hands on me. So he's in there for no reason.
Okay, Ms. Cruz, did you call the police in this matter?
No, sir, I did not. A neighbor called.
Okay, and has this ever happened before?
No, sir.
And are you afraid of him?
No, sir. We've been together over 6 years. I hope to marry him one day. He's an amazing guy.
Okay, and so I take it that you do want to have contact with him.
Absolutely.
Okay. Any questions from council?
No, Judge, I mean,
Mhm.
that is also what Mr. Ferguson said to me. They have a Great Pyrenees, and he said that the dog had jumped on Miss Cruz.
Okay. Thank you, Ms. Cruz. We appreciate your testimony this afternoon.
Thank you.
If nothing further, it's going to be a $3,000 signature bond through pretrial per the judge. 1 day anger awareness, no further violent contact with Ms. Cruz, and no drugs, alcohol, or weapons while out on bond. All right, Mr. Ferguson, good luck to you, sir.
Thank you, Judge.
Welcome. Who do we have next?
Position number 4, judges, next, please.
Good afternoon, Ms. Deutsch Fernandez. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video? Thank you. You've been charged in case 22 CR 008490F with battery, family violence, and cruelty to children in the 3rd degree. Is there a history, Ms. Harrison?
Judge, no prior history.
Mr. Borger?
Thank you, Your Honor. The state is asking for a $5,000 surety bond. That's $2,500 for each charge, along with the conditions of no further contact with Daisha Fernandez. That's DEISHA Fernandez, and no further contact with Tamika Wright, TAMIKAH Wright, WRIGHT. Stay away from 3871 Red Wine Road. Enrollment in the Family Violence Intervention Program, or at least the anger awareness class, and no guns, drugs, and alcohol while on bond. Your Honor, in this case, Ms. Fernandez, this defendant here, went over to Miss Wright's house where Miss Fernandez's wife was living. They are still married, but I do understand that they are going through a separation. And that is when the defendant had punched Miss Fernandez in the face, grabbed her hair. This did cause visible swelling and bruising to Miss Fernandez's face. There were children present at the home. So the state does think that a $5,000 surety is appropriate, just because it appears that Miss Daisha wanted her space from Miss Fernandez and was attempting to seek some sort of refuge. And here she is getting punched in the face in front of small children, and just needs peace and alone time as they go through this separation. So we do think that 5,000 surety would be appropriate. Nothing further.
Jenks?
Thank you, Judge. We're asking you to allow a signature bond in this case, Judge. I mean, most of this case will really be couched in a family law court. Miss Fernandez and also Miss Fernandez, they're legally married. They have 3 children together. The first 2 were birthed by Disha. The third one, who is 1-year-old, was birthed by my client. They were together for over 6 years, Judge. There's no need for her to go to the location where Disha resides. She's now residing with a new girlfriend. And also my client denies punching Disha and denies the allegations in this. She was there to see her kids. So we're asking you to allow signature bonds. Ms. Fernandez works for Delta Airlines. She's a ramp agent. She's been doing that since August. And as I said, she's been here for over 6 years. So we're asking you to allow her a signature bond. No further contact is fine, and a 1-day anger management as a condition would also be fine.
Is she gonna need third-party transfer of the minor children?
Yes, that's also, yeah, sorry, I forgot that.
Okay. So for the battery family violence, a $2,000 signature bond through the jail. For the cruelty, $1,000 signature bond through the jail, makes it a total of a $3,000 signature bond through the jail. No further contact with Daisha Fernandez or Tamika Wright. Stay away from the Red Wine Road address. Third-party transfer of any minor children. And no drugs, alcohol, or weapons while out on bond. Ms. Jenks, at the appropriate time, would you explain to her what third-party transfer means so that she doesn't get in trouble with that? Basically, Ms. George Fernandez, I'll allow both of you to see your children, but you're not gonna, since you can't have any contact with Daisha, then you're gonna have to have a third-party go-between for visitation with the children, okay? All right. Good luck to you, Ms. George Fernandez.
Thank you.
Thank you, Judge.
Position number 12 is next, Judge.
Okay. We've already done position 12. I've got that as Yasmin Wright. Is that not correct?
Oh, I'm sorry. Well, this should be Tracy Williams. Maybe
Okay,
it's 13.
I think she's 11.
Position 11.
Oh,
Okay.
thank you. I'm sorry.
Good afternoon, Ms. Williams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Williams, you've been charged in case 22 CR 008495G with simple battery and criminal trespass. Is there a history, Ms. Harrison?
No prior history, Judge.
Okay. Ms. Backus?
Yes, Your Honor. This incident occurred on December 19th. An officer was dispatched to 210 Armis Place in reference to a physical altercation. Upon arrival, the officer did speak with the victim, Miss Tashia Finney. Tashia is spelled Tashea. Last name is Finnie. She said she was involved in a physical altercation with the defendant. She explained that herself and the defendant had recently fell out over an incident with a mutual friend, and they hadn't spoken to each other in several months. But despite that, the defendant showed up to her residence unannounced and uninvited. An argument took place at the door, and then the defendant forced her way into the residence without authorization, sat down on the couch. I guess the defendant was attempting to grab Ms. Finney's hand. She was calling her the B word while also trying to hug her. So Ms. Finney asked her to leave several times. She wouldn't leave, and that's when a physical altercation took place. And she said that the defendant struck her several times on various parts of her body, and her children had to forcibly remove the defendant from the residence. Our office was able to speak with Ms. Finney. She said that they were best friends for like 30 years. This was, I guess, an emotional situation. She came to the house, they got into the fight. She did say that she wanted no contact and to stay away from her home. But she did say that she did not want to press charges. However, Your Honor, based on the nature of the offense, the state would be asking for a $2,000 surety bond. That would be $1,500 on the simple battery, $500 on the criminal trespass. No further contact with Tashia Finney. Stay away from that incident location of 210 Armis Place, and 1 day anger awareness. Nothing further.
All right, so for each count, it's going to be $1,000 signature bond through the jail, makes for a total of a $2,000 signature bond through the jail. Stay away from the Armistice Place address, no further contact with Ms. Finney, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Holly?
It does. Thank you, Judge.
All right. Ms. Williams, I'm going to let you out in a signature bond, but you're not going to be able to have any contact with Ms. Finney. You'll go back to her or her residence, okay?
Perfect.
All right, good luck to you, Ms. Williams.
Position 1, Mr. Bell.
Good afternoon, Mr. Bell. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Sorry, I do.
Thank you. Mr. Bell, you've been charged in case 22 CR 008487J with battery, family violence, willful obstruction of a law enforcement officer, and cruelty to children in the 3rd degree. Is there a history, Ms. Harrison?
Judge, 33 cycles. Last arrest, April of 2021 for a parole violation in Fulton County. Record indicates a 2018 felony conviction, damage to property 2nd degree, 2 counts out of Clayton County. Also, misdemeanor convictions, 2018, disorderly conduct, 2016, simple battery, 2 counts, and obstruction of law enforcement officers, 2011, obstruction. He was under first offender, does not indicate it was sealed. Nothing further, Judge.
The 2016 simple battery, you have any indication if that's what happened with those charges?
The 2016, that was a conviction.
Okay. Thank you. Mr. Berger?
Thank you, Your Honor. The state's asking for a $6,000 surety bond. That's $2,000 for each count, along with the conditions of no further contact with Miss Jenna Harris, enrollment in the Family Violence Intervention Program or an anger awareness class, and no guns, drugs, and alcohol while on bond. Your Honor, in this case, Mr. Bell had pushed Miss Harris to the ground. It looks like she hit her head on a table, causing her to bleed from her head. When the officers came into the home, there was visible blood on the ground. The apartment, the home, was in complete disarray. It appeared that Mr. Bell was under the influence of maybe some crack cocaine, because his eyes were showing dilation, and there was some white powder along his lips. Mr. Bell was largely incoherent as well. Couldn't really put together any thoughts and seemed hyper paranoid. Combine this with the fact that the defendant's 17-year-old daughter, Ms. Wilcox, witnessed the entire incident. This is just largely disappointing. I mean, to see blood on the ground, sounds like this really could be a felony right here as we continue to investigate the case. Along with the history of violence that Mr. Bell has, a multitude of probation violations. I'm looking right here, 1, 2, 3, 4 at least that are even showing guilty. Most recently from 2017, had a criminal damage to property, guilty 2017. I count 4 FTAs, a driving on a suspended, guilty, obstruction, guilty, another obstruction from 2015, guilty, and then battery of a police officer, 2016, guilty. So we're seeing a lot of violence, but also a lot of disrespect for this criminal justice process that we have. I'm not so sure what we're doing here is making quite an impression on Mr. Bell, which is why we do think that a $6,000 surety would be appropriate as we evaluate this case for a potential felony. Nothing further from the state.
I don't believe I heard a stay away. Is that they're not one requested?
I didn't request a stay away. So the state would be asking for a stay away in the incident that if this is Miss Harris's home. So we have the address 2701 Alta View Drive. It's difficult because I just don't know if that's Miss Harris's address, especially considering that Mr. Bell's daughter was at the incident location. Of course, I'm not sure what the family situation currently is right now, but the state would be asking for a stay away.
You enlighten me on that, Ms. Jenks?
He did give me his address of 2701 Alta View Drive. I don't know if they live there together. I think I forgot to ask, but I do want to respond to everything that the state has just said when you get
Of course. Go ahead.
Judge, first and foremost, there's obviously no charge of any kind of drug involved. This recitation of crack cocaine, I think that, you know, we can credit the officers with the fact that if they really thought that there was something there, we'd see another charge here. Also, I didn't hear much of drugs in his history. But even that aside, Judge, and I don't know if you had an opportunity to read the probable cause warrant. I mean, with 33 cycles, let's face it, most of the time it would be disingenuous to ask for a signature bond considering Mr. Bell's history, except for the fact, and why I'm going to ask Your Honor to consider a signature bond in this case, you can clearly see that in the third paragraph on the probable cause warrant, Judge Wilcox, who is the independent 17-year-old witness in the case, and I guess the state's star witness when this moves forward to trial, advised that Harris was the first one to place hands on the other. And she was also arrested, which I guess is why the state didn't have any information as to whether or not that's her residence. And I don't know. I looked on the pull sheet from Saturday because I wanted to see if there was a conflict. I'm not sure if and when she was in first appearance, because obviously we wouldn't be able to represent both parties, but I didn't see her on Saturday and I don't see her on today's. Mr. Bell is 43 years old, Judge. He's lived in Atlanta for over 20 years. He did graduate high school. He was the class of 98 from Jonesboro High School. He didn't go to college, but he was working consistently doing at GSO Logistics as a forklift driver. Again, in this case, Judge, we're going to ask you to compartmentalize his priors and just look at the facts of this case where she, in fact, was the primary aggressor as sworn in this probable cause warrant and allow him to sign his own bond. Condition of anger management, if you wish.
And I would like to respond. First off, looking back at this warrant, the warrant describes the defendant as living with the victim. So we are going to go forward on that stay away. Because this does appear to be the victim's home. But also, Judge, as Your Honor knows, you don't need to compartmentalize the facts of this case with this defendant's history. We actually need to consider the defendant's history and his ability to return to court, which is not very promising because, again, looking at his history, you see a lot of probation violations and driving on a suspended. That is absolutely something the court takes into consideration when deciding bond. That's why we're here. Nothing further.
Mr. Burwell, was Ms. Harris arrested? And can you enlighten the court as to what is going on with her?
Yes, Your Honor, I'll look into this right now. But the fact that she's not on this SCA pool sheet would make it a little bit more.
My concern if this happened yesterday? And
the 24th.
Oh, okay, I forgot the 20. Okay, so if she was seen and she's been ordered to stay away and he's ordered to stay away, I don't want to have conflicting orders to stay away from a resident.
And she was arrested according to the warrant for domestic violence, Judge. That's in the third paragraph.
Okay. Well, I don't understand why she's not on this calendar or.
She's not showing in my Odyssey, so I'm not even sure.
Okay.
So as of right now, we have, I mean, respectfully, it's just Miss Jinx's word to our word. We don't have any indication that she was.
Well, I think that
Judge, please read the warrant. It's absolutely not just my word.
Hold on, Miss Jinx, hold on. We're all doing the best we can here, Mr.
And the warrant does not say that she was arrested. I don't know where this is coming from.
And has your office reached out to her, Mr. Berger?
We have attempted to make contact. We just haven't gotten an answer.
Okay. Anything further, Ms. James?
I mean, I'm just concerned about, I'm looking at the arrest affidavit that was forwarded to me from the jail and the paperwork that we evaluate these cases on in preparation for this calendar, Judge. And I'm just, it just causes me to pause that the state, I mean, I'm happy to forward this to both the state and you, Your Honor. I'm reading it from the affidavit for arrest that is signed by Nancy Mao, Judge Mao. So, I mean, do either of you have this, or maybe the jail can forward it to you?
Ms. James, if you'll just tell me what it says, I'm perfectly fine with that.
Sure. This is the third paragraph. Wilcox advised that Harris was the first to place hands on the other, and Bell escalated the altercation. Due to his agitated state, I then arrested Harris for domestic violence, double locked in parentheses, and advised radio that Bell was in custody as well.
I have the incident report right here to clarify what had happened was warrants were taken out for both parties. But the judge, I guess in this case, Judge Mao, preferred that there be a predominant aggressor cited. So in that situation, then Bell was cited as the primary aggressor, and Ms. Harris was released, and it's quote back to her residence. So this is determined as not only her residence, but she was also released after determination from the officers and after speaking with the judge. That's just what it says in the incident report.
Okay, I mean, that's totally contradictory, and I'm seeing Nancy Mel's address, signature on here, and it talks about both people being arrested and warrants taken out.
Right, but then, and then Ms. Harris was released.
I mean,
Okay.
she may have still been arrested and been released and not processed at jail. I mean, that does not make sense to me based on how this warrant reads, Judge. I don't know.
Well, it says right here that Bell was the predominant aggressor and Harris was released and transported to her residence. I don't
And
know
Your
what else to
Honor, I
say.
think the issue is that we have the police report and Ms. Jinks has the warrant. And so I think there's a disconnect there. So we can get the police report to Ms. Jinks so she can read that as well, but we have additional information outside of the warrant.
Okay. Anything further from anyone?
No further.
Thank you, Ms. Sweat. For the battery family violence, it's going to be a $1,500 good bond. For each of the other two charges, it's going to be a $250 good bond, which makes it a total of a $2,000 good bond. At this point in time, no further contact with Ms. Harris, and stay away from the Alta View Drive address. You can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. No drugs, alcohol, weapons while out on bond. If it comes to light that Ms. Harris is not at that address, of course, Ms. Jenks, I would certainly consider a modification of this order. Mr. Bell, good luck to you, sir.
I'll explain after. Position 10, Mr. Ralston.
Good afternoon, Mr. Ralston. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. Mr. Ralston, you've been charged in case 22 CR 008494B with loitering and prowling. Is there a history, Ms. Harrison?
Yes, Judge. 46 cycles, last arrest, April of 2022 for willful obstruction of law enforcement officers by use of threats or violence, criminal trespass, and damage to property, second degree, removal or attempt to remove weapon from a public official. Record indicates that's an open case pending, and one moment. That's his last arrest. He has an open case pending in DeKalb County for those charges, Judge. It's under case D as in David 0289687. Record also indicates an open probation in Fulton County. I'm sorry, open case 21 CR 003822B like boy. And that's for obstruction of law enforcement officers, loitering and prowling, and that is open in Judge Porter's court. Misdemeanor conviction 2020, he has a trespass, 2020 obstruction, and 2018 obstruction, criminal trespass, 2017 simple assault, giving false name, obstruction of law enforcement officers, and pedestrian in roadway. He has a 2016 felony conviction for aggravated assault, 4 counts, damage to property in second degree, simple battery under case 15 SC 137004. A 2014 felony conviction for possession of methamphetamine. Nothing further, Judge.
Thank you. Ms. Backus?
Yes, Your Honor. This incident occurred yesterday. An officer was dispatched to 2441 Cheshire Bridge Road in reference to a prowler call. The caller stated that the defendant was seen at the location pulling on doors and looking through the windows of a commercial building plaza. Upon the officer's arrival, he did observe the defendant in the rear of the building and trying to exit the lot where there were the cars were parked. The officer did ask several questions just to make sure that the defendant was coherent, understood where he was, and he ascertained that he did. And at that time, he placed him under arrest. Your Honor, in addition to the 46 cycles, the defendant also has a warrant out of Hall County for criminal trespass. I believe there's already a $1,000 surety bond in place. So we're asking that $1,000 surety bond would remain in place and stay away from that incident location. Again, that address is 2441 Cheshire Bridge Road in Atlanta. Nothing further.
Thank you. Ms. Holly?
Yes, Judge. Mr. Ralston has lived in Georgia all his life. He does work in construction and lawn care, doing jobs, and he does live in the area of Cheshire Bridge. After speaking with him, my understanding is that he was hoping that one of the stores would have been open, and he went to the space and then left. I'm not sure where the state sees a problem with him after leaving. I understand that someone was called out to the incident. He does have a child who's 14, a son who he does help support. We would ask for this to be changed to a surety bond. I understand he has a number of cycles as well as open cases, but with the circumstances of this arrest, I just would ask the court to consider a signature bond so that he can at least go to Hall County and try to handle that case as well.
Your Honor, just briefly, I would say that I do understand we don't know everything yet, but what I will say is that in order for a person to pull on doors and to hope that one is open, that takes but a few moments. This, however long he was out there pulling on stuff, it was a long enough period to where somebody saw it, called the police, and the police had time to come and arrive. So therefore, it doesn't appear to the state that it was just a quick pulling on and then an exiting. Nothing further.
Okay, I'm going to release him so he can go deal with that warrant. It's going to be a $2,000 signature bond through the jail. Stay away from 2441 Cheshire Bridge Road. No drugs, alcohol, weapons while out on bond. Mr. Ralston, I'm going to release you so that on a signature bond so that you can deal with your other matters, but you're going to have to make sure to come back to court at your next hearing date. Otherwise, they're going to put a warrant out for you, okay? Good luck to you, Mr. Ralston.
Hey, Jan.
Ms. Holly?
Mr. Ralston, we're not discussing the case right now.
Ma'am, I feel targeted, ma'am. Like they targeting me.
Mr. Ralston, you've been given a signature bond so that you will be able to get out. And as we discussed, you will handle the case later.
All right. They're targeting me for walking down the sidewalk, ma'am.
Mr. Ralston, everything you're saying is on the record and you're not helping your situation.
Position 9, Palmer.
Good afternoon, Mr. Palmer. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah, I agree.
Thank you. Mr. Palmer, you've been charged in case 22 CR 008486C with battery and simple battery. Is there a history, Ms. Harrison? You're on mute if you're talking, Ms. Harrison.
I apologize, Judge. 4 cycles, last arrest, November of 2012 for armed robbery in Cobb County. That was a conviction. It appears he's still on probation for that arrest. He was convicted December of 2012, 8 years confinement with 12 years probation. Case number is 12M5017. He has 2 misdemeanor convictions, 2011 theft by shoplifting and a 2012 obstruction and possession of marijuana. He does have 2 or more failure to appear and does not have more than 3 violations within the past 10 years. Nothing further, Judge.
Thank you. Ms. Backus.
Yes, Your Honor. The state is asking for a $5,000 surety bond, $4,000 on the battery, $1,000 on the simple battery. No further contact with the victims, Delaney Wilkins. Delaney is spelled DALANIE, And the second victim's name is Shakara Richmond, Shakara, Richmond, common spelling. Officers were dispatched to 780 Crestwell Circle. Upon arrival, they spoke with the parties on the scene, which is Miss Wilkins, Miss Richmond, and then a neighbor who had come over to help Mr. Robert Rice. The officer spoke with all of them and spoke with the defendant, was able to ascertain that there was drinking going on. So the defendant was drinking at some point, became upset and belligerent. He became upset with Miss Wilkins. He took his hand, pushed her in the face, and then pushed her down to the ground. So that's when Miss Richmond came over, tried to protect Miss Wilkins. And the defendant grabbed and pushed her to the ground, and the officer did observe a bruise on her right breast. That would be Miss Richmond. And then all three of the individuals did confirm to the officer that they were basically trying to stop him from hurting them, but he was intoxicated and too strong for them. Your Honor, again, the state is asking for that surety bond. The defendant is already on an open probation for another violent offense, an armed robbery. Yeah, nothing further, Your Honor. We would ask that surety bond be put in place.
Crestwell Circle, what address is that?
780 Crestwell. It looks like it's Crestwell Circle in Atlanta.
And whose address is that?
That I believe is Miss Wilkins' address. Let me pull up the report.
I think that's correct.
Okay, thank you. Ms. Holly?
Yes, Judge, he doesn't have any issue with the stay away or no further contact. Mr. Palmer was not the only one who was intoxicated. Everyone at this party was intoxicated. And actually, Mr. Palmer was the only one with serious injuries. He went to Grady and received 2 staples in his left leg after this incident. He does have a good job. He's actually a supervisor with Sweeping Corporations of America. We would ask that the court grant him a signature bond. I understand that he does have remote criminal history, over 10 years old for that conviction, but he has been completed that probation, though it is not closed. He is on non-reporting. So we would just ask that the court consider a signature bond. Of course, he will consent to all of those conditions, the stay away, the no further contact, and if the court wants to put in place other conditions that they see fit as well.
All right, for the battery, it's going to be a $1,500 good bond, simple battery, a $500 good bond, makes a total of a $2,000 good bond. No further contact with Miss Wilkins or Miss Richmond, stay away from the Crestwell Circle address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Palmer.
I'm sorry, Judge, can you please repeat the bond?
It's $1,500 for the battery and $500 for the simple battery, a total of a $2,000 good bond.
Thank you.
You're welcome.
Position 8, Owens.
Good afternoon, Mr. Owens. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Owens, you've been charged in case 22 CR 008485Y with driving under the influence of alcohol less safe and following too closely. Is there a history, Ms. Harrison?
Yes, Judge. This is his 3rd arrest. Last arrest was August of this year for interference with custody, 1st or 2nd conviction. That was out of Roswell, Georgia. That is an open case. 22 CR 005558Y. Additional open case for aggravated assault, family violence in Fulton County, 22 CP 11298. Nothing further to add, Judge.
Okay, Ms. Backus.
Yes, Your Honor. I'm sorry, 1 second. My apologies. In this case, Your Honor, the state is asking for a $7,500 surety bond, $5,000 for the DUI, 2.5 for the following too closely. No alcohol, drugs, or weapon, no driving. As you heard, there are the 2 open cases where he's already out on a $10,000 surety bond on one. And then that's on the felony, and on the misdemeanor, there's a $2,000 surety that is open with Judge Mincy for that interference with custody. This incident occurred on the 24th. An officer responded to an accident scene at Georgia 400 northbound, just south of exit 7A. Upon arrival, the officer observed a traffic accident. It involved 3 vehicles. 2 of the vehicles sustained major damage, required to be towed from the scene. The officer then spoke with the defendant, who was still seated in the driver's seat. The airbags were deployed. The front of the vehicle had sustained major damage. When being spoken to, the defendant was slow to react. As soon as he opened the door, the officer noticed that he smelled alcohol coming from not only the person, but inside of the vehicle. Eyes were bloodshot, red, glassy. He initially told the officer he had nothing to drink, but then he said that he had a shot. The officer did note that this incident occurred because the defendant was traveling at a high rate of speed. He was following too closely behind one of the vehicles. He hit that vehicle. That one spun out, hit a guardrail, and then hit that 3rd vehicle. And as Ms. Jenks said earlier, the field sobriety tests were not administered because of the weather conditions, but he was placed under arrest for DUI less safe. They did read him the implied consent, and he did consent to a blood draw. The state has requested those results. We do not have them yet. But in light of the open cases, having already 2 open bonds, the state would ask for that surety bond on both the charges. Nothing further.
Ms. Holly?
Yes, Judge. Mr. Owens does have a good job. He works for Oxen Boy Logistics as a team lead. He does have that job continuing, and he also does live in this area. I've spoken to him about this incident. After reading the report, the officer stated multiple times in the report that the conditions on the street were extremely dangerous for driving, and that Mr. Owens was in a serious accident. I think it's a serious consideration in terms of his reaction time, the way that he responded, and also the presence of bloodshot and glassy eyes, because all of those things can come from being in a serious accident, which we are aware that he was in. He did consent to the blood draw, and that was given at the hospital. So we are waiting for that. We would ask for a signature bond on this case, and so that he can return to work. He does have a 1-year-old child, Josepha, who he supports.
Your Honor, I would agree with Ms. Holly. She is absolutely right that we don't have all the facts and that those things could definitely come from an accident. The only thing that I would highlight again to the court is that he did admit to drinking to the officer. Nothing further.
For the DUI, it's going to be a $1,750 good bond. For the following 2 closely, a $250 good bond, makes for a total of a $2,000 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Owens.
Thank you, Judge.
Judge, I do have a quick announcement for.
Okay.
For position number 6, it's going to be a medical reset.
For tomorrow?
Yes.
Okay, for the 27th, okay.
And that's it. We're completed here in Portland, Judge.
All right, fantastic. Thank you so much. We'll see you in the morning. Is that
All
right?
right. Thank you.
Okay, all right.
All right.
Thanks.
All right.
Thank you, Judge.
So we'll go over the calendar if you all would like with
Okay.
Ms. Lewis, and just to make sure we have everything right.
Okay. Position number 1, I have a total of a $2,000 good bond. The case is reset for the SAP counter for January the 10th of 2023. So I wanted to keep repeating that so everybody know the SAP is January the 10th of 2023. Position number 2 is a $1,000 SOB through the jail. We set further notice. Position number 3 is a $2,000 SOB through pretrial. The case is reset further notice. Position number 4 is a $3,000 SOB through the jail. The case is reset further notice.
I'm sorry, can we go back to position 3? You said it was SOB pretrial?
Yes.
And that's what I have also.
Me too.
It's a no further contact, stay away, and a 1-day anger management, and no alcohol and drugs, and no weapons. You got that, Ms. Harris?
Got it. Thank you.
You're welcome. Where was that? Position number 4 is a $3,000 SOB through the jail. The case will be set for the notice. Position number 5 is a $3,000 SOB through pretrial per judge. The case is reset for the notice. Position number 6 is reset for the SAE counter for tomorrow, December 27th, due to medical reasons. Position number 7 is a total of a $2,000 surety bond. The case is reset for SAP. Position number 8 is the same announcement. The case is a $2,000 surety bond. The case is reset for SAP. Position number 9 is a $2,000 surety bond. The case is reset for SAP. Position number 10 is a $2,000 SOB through the jail. The case is reset for the notice. Position number 11 is a $2,000 SOB through the jail. The case is reset for the notice. And position number 12 is a $3,500 good bond. The case is reset for the competency counter for January the 12th. Any questions?
Nope.
Concerns?
Sounds
All right.
good.
You all have a good rest of your evening. It's good seeing everybody that I don't see all the time, so.
Thank you.
Thanks, Judge. Have a great night,
Happy
guys.
holidays.
Thank
Good
you.
evening, you all.
Bye-bye.
Um,
I'm sending them right over to you, Judge.
okay, good.
I got a
And
lot of
are you